Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name is Mark Solomon, a criminal defense attorney in Denver, Colorado, and today's question is about minor in possession of alcohol or marijuana. Before we get to the actual question, don't forget to click like on this video and subscribe with a little bell next to it to be notified of future videos. So let's get to the question. What is minor in possession of alcohol or marijuana? And the answer is in the statute. Here we go. So, notably, this is not just about possession. It's also about consumption. Notice I highlighted both in the beginning. It says that if you are in possession of it, you can be charged with this crime, but also if you're under the influences, and we're going to get to the evidence, standard of evidence that the police and the courts are going to use to be able to prosecute a minor for the statute. But it means that if an officer suspects you're under the influence with reasonable suspicion or probable cause that you're under the influence, he can charge you with this minor in possession charge. What are the possible penalties for that? It's gradated into first, second, and third offense. So first offense, second offense, third offense. I have summarized that so that you can see a first offense is a fine of up to $100, and the judge can order a substance abuse evaluation and treatment. On a second offense, the fine is still up to $100, but the court can also give an offender up to 24 hours of community service and shall sentence the person to complete a substance abuse evaluation and treatment. On a third or more offense, the fine does go up to $250 with up to 36 hours of community service, and again, court shall order the substance abuse treatment. Now, there's some other interesting things in this statute. For example, the standards of proof for prosecuting somebody, which literally is just prima facie evidence that the person committed the crime. Things they need to prove, two things: under the age of 21 and either in possession of alcohol or marijuana or exhibiting indicia of intoxication commonly associated with that. And they can testify to that. Now, this statute also has what I call a safe harbor for first aid, which means that if an underage person calls 911 to get medical treatment from somebody else, then he is immune from prosecution. So that's good. The law has chosen life over punishment. Now, another nice thing is built into the statute, sealing of the case. So complete one of these charges, and it is just built in. There's no discretion by the judge. This case must be sealed after the case has been committed on a first offense, and there's some other loopholes that you have to, not loopholes, there's some other hoops that you have to jump through on a second or more offense, but all of these can be sealed. So that is the question and answer for today. If you would like your own question answered in a future video, you can submit it by either putting it in the comments below, emailing it to me, or tagging me on Twitter. And as always, you have a right to remain silent. If a police officer is asking you questions about what you've done, where you've been, what you have, or what you know, you always have a right to say, "I don't want to talk to you," or "I want a lawyer."